I'm Las Vegas defense attorney Ryan Alexander. If you've been arrested for a DUI in Nevada, two processes will start simultaneously. The first is in the criminal court, and the second is in the DMV. I've explained the DMV process in another video, and now we're going to focus on what happens in the criminal court. You're going to have to make 3 appearances in your DUI case. The first is the initial appearance, when you're going to see the judge for the first time. That's when they're going to set the bail amount or release you on your own recognizance. At that time, the charges will be read to you, and you'll either be appointed the public defender or given the chance to hire a private attorney. From there, they will set an arraignment date. Now, it could be within a week, it could be within 5 months, but they will set the next court hearing, which will be your arraignment. You're going to go to arraignment to enter your plea. By this time, you will have hired a defense attorney. You'll go to the hearing. It's very brief. You're going to enter in your not guilty plea. The bail can be reviewed at that point if necessary. Sometimes the court will even exonerate your bail and give you your bail money back if you've paid cash bail. From there, they will set a pretrial hearing in municipal court or straight to trial in justice court. This will be another 4 to 6 months out. So you should expect your DUI to take anywhere from 4 months to over a year to complete. At the arraignment stage is where you're going to get the discovery materials, which include the police report and any nurse reports and certifications regarding your blood alcohol tests. You'll meet with me. We'll go over all of the discovery materials in detail, and I'll tell you exactly what can happen in your case. Usually, before the trial phase, the district attorney and I are going to meet, whether by phone or in person, and go over your case. And we're going to talk openly about the strengths and weaknesses of your case. Most cases are negotiated before trial. In fact, less than 10% of all cases go to trial. Most of the time we can figure out what is going to happen in your case before an actual trial, just from the evidence that's presented. You and I will go over what type of offer the state is making and the material, again, to determine what we can do at a trial. If we hold a trial date, that is when the police who arrested you and the nurse who examined your blood or any technician that operated the breathalyzer or intoxilizer machine are going to come and testify as to why you were stopped, what happened at your stop, what happened when they took you back to the station, the exact process of how they tested your breath or blood, and the results of your blood alcohol testing. We also have the opportunity to put on a defense of any witnesses or any experts that we need. You don't have to testify at your trial. You have the right to not testify and not participate, but to observe the charges and all the evidence against you. If you're found guilty of a DUI or you take a plea deal, you'll have 6 months to complete the requirements or sentence after the final hearing where your sentence is imposed. We'll have a status conference in the 6 months where I will go back on your behalf and report that you've completed all of your requirements. If you're having problems getting your requirements completed, you must tell me as your attorney so that I can make preparations and arrangements to get you an extension. Otherwise, you could be found in contempt of court, or the court may issue a bench warrant to bring you in before the judge and explain why your requirements are not complete. If you've been arrested for a DUI, call me, Attorney Ryan Alexander, at 702-868-3311. And I'll go over the specific facts of your case and tell you how your criminal case is going to work in Clark County.